just open discussion about whatever issues you'd like to bring up, either in relation to assessment or other matters. So basically, over to you.
Michael, I wanted to have a little bit of clarification regarding radical title. Was that, I'm not quite sure where that originated from. Was that a notion that was invented because of Mabo to have the doctrine of tenure acknowledge native title rights? Is that where that whole notion of radical title came from, or what have I missed? Because I can't seem to figure out where it originated from.
Does anyone else want to proffer a view on that or contribute to that, the idea about the discussion about native radical title? No? Okay. Down to me. Look, it's really, about how title was acquired, if you like, from the perspective of the Crown. And it's a form of recognition of how title was acquired through this process of settlement or colonisation, which was different to the English history of how title was taken, by the monarch, the sovereign, as that emerged in England. So, if we have a look at, for example, just to anchor ourselves back in some material for you. We go back into I'm just trying to find a reference in Mabo, because I think Brennan sort of encapsulates that very well. All right, so, for example, on page 98 of your case book, so really it's in the first paragraph. Well, the continuation of the paragraph from the previous page over onto page 98, about halfway down, where Justice Brennan says, the radical title is a postulate of the doctrine of tenure and a concomitant of sovereignty. That is, it's there functioning with the idea of sovereignty. As a sovereign enjoys supreme legal authority in and over a territory, the sovereign has power to prescribe what parcels of land and what interests in those parcels should be enjoyed by others, and what parcels of land should be kept as the sovereign's beneficial demesnes. By attributing to the Crown a radical title, next paragraph, to all land within a territory over which the Crown has assumed sovereignty, the common law enabled the Crown, in exercise of sovereign power, to grant an interest in land to be held of the Crown to acquire land for the Crown's demesnes. The notion of radical title enabled the Crown to become paramount lord of all who hold a tenure granted by the Crown, and to become absolute beneficial owner of unalienated land required for the Crown's purpose. Here's an important corollary to that can't be omitted. But it is not a corollary of the Crown's acquisition of a radical title to land in an occupied territory that the Crown acquired absolute beneficial ownership of that land to the exclusion of Indigenous inhabitants. You see, that's why the recognition of radical title as the type of title that the Crown exerted as a consequence of the assumption of sovereignty in the settled place, that native title could still be recognised by the court in 1992 in Mabo, and also how the court was able to recognise in 1992, but very belatedly, in my view, and the view of others, that this landmass had never been terra nullius. Next. Thanks for that, Lisa. It's a very good question. And, trying... Sorry, go on.
Yeah. So in order to recognise native title, they had to firstly recognise radical title. Is that right?
No, radical title was basically the mechanism whereby the Crown was able to assert beneficial ownership of land in a place over which it asserted sovereignty. I mean, this idea of asserting sovereignty, again, this touches on a point that one of you raised earlier, and that is about, the fiction of the Crown, arguably today, in terms of how, in practical terms, the Crown operates. But we still operate under the fiction that the Crown is at the apex, that the monarch is at the apex. We have, as I was saying jovially earlier, we have them parading around the country at the minute, or some of them, not the actual sovereign. I mean, she's a bit too old now to be parading around Uluru, but we have members of the monarchy parading around, and they are just we have this. I almost think it's almost today like a sycophantic relationship with monarchy, in that we want to almost make them some sort of modern incarnation that we can feel comfortable with in the modern period, where the idea of monarchy is totally displaced. So, we dress them up in ordinary clothes and we let them do ordinary sorts of things. But at the end of the day, they are still members of the monarchy. And the monarchy is deeply rooted in our law and in other aspects of our institutions, whereby they are arguably the ultimate authority and the ultimate source. And that is true in ownership of land. Through the assertion of sovereignty, that is the assertion that they have an absolute right to come and take this place. As a consequence of that, they then derive the ultimate beneficial ownership, if you like, of the land through this idea of radical title. It can't operate in the same way as feudalism operated in England, because that's not the circumstances in a settled colony by colonising power. So that's where this idea of the type of title that they get is born, and it's called radical, I suppose, because it is a break from whatever was there before, either nothing or something that was not recognised. Did exist but wasn't recognised, which is the case in Australia.
Yeah, thanks for that, Michael. I have a much better grasp of that now.
Okay, that's good. Other questions, people? Feel free. I promise not to impose any lordship financial burden.
Hi, Michael. It's Jessica here.
Hi.
I see if my bandwidth will handle this. But in regards to answering quiz questions,
Yes. Good.
Is it appropriate that we can look at other parts of law, such as constitutional, as it relates to land law? So far, I've been very kind of tunnel visioned with it and been afraid to go off on tangents. But after tonight's discussion, I'm just wondering about that.
Thanks, Jessica. Very good question. Would anyone else like to proffer a view on that?
I would tend to think that, looking at a whole range of information sites where you may be able to find the answer to the question that's being posed, I always find the fact that you can look around and draw in other aspects of law always very useful and very helpful, and it's informative for yourself as well.
Yep. Thanks, Margaret. Thanks for that. Anyone else? All right. Now, let me say this in response to not just quiz questions, but all forms of assessment. So this includes the final exam, and in what is remaining in terms of any posts you put up to questions, tute questions and so forth. It's really important, always important, to primarily engage with the key words and the key concepts in the question. Do not permit yourself the indulgence of your answer wandering off into a frolic. That might sound a bit harsh, but what I mean by that is no assessment task is ever a reason or an excuse for you to just go off and talk about what you think is the area of law or the topic, the thing that you think is there, but you're not actually ever systematically engaging with the key concepts in the question. Have to ask yourself, what are those key elements of the question? I always think that looking for keywords in a problem-solving question, legal problem-solving question, you're looking for key pieces of information. You're reconstructing a scenario by use of a diagram or a timeline, very helpful. What are the key pieces of information that is of critical relevance? First and foremost, in a property law sense, because that's what we are assessing in the context of the ideas and the concepts that we're introducing you to in this course. Having said that, of course, it's fairly evident from my course that there's a fairly broad canvas upon which the course is being cast and which I want you to think and reflect. So my response to that question, Jessica, is that make sure you be systematic in your treatment of the key ideas and the key concepts being brought out in the question, linking back to the key material and that we've discussed. But I want to encourage you and I want to embolden you to think about the broader implications. And specifically where I'm pointing you in that direction, so for example, I refer to the Constitution, I refer to the Human Rights Charter, the UN Human Rights Charter. Obviously, I want you to engage with that in some way. Okay, but it's like a conditional delimitation, isn't it? Always a but in law. So the but is that you always must ground your points and your arguments in law, in case law, in appropriate academic commentary, and in legislation as appropriate. We haven't seen a lot of that in this course. The Property Law Act, 1974, has cropped up from time to time, and that is a critical piece of legislation, both here and in the next course, land law. And just on that point, I bring to your attention the what I've put on the website with regard to the ongoing review in Queensland by the Department of the Attorney General to key pieces of property law legislation in Queensland, which includes the Property Law Act and other acts that we don't really look at too much in this course, but the Property Law Act is one. And that's an ongoing process, but just be aware of it. It's part of law reform. And we want you to be aware of current debate, current reforms that are touching the area of law that you're looking at. But by all means, look at these broader areas, but ground any reference you have in law by reference to critical sections or provisions, case law, academic commentary that's appropriate. Yeah, but I need to see that in your answers. I need to see the referencing in your answers. I know, and look, I'm not going to apologise for the Moodle system. There are some issues with the Moodle system in various ways, as we all know, coming to love the Moodle system or not. But within the parameters of what you've got available there, you do need to show me the law that supports your answer. Okay, I am harsh with people who show me no legal basis for their answers, because that is not the way that we proceed with in legal writing. We must have our answers grounded in the law. And the other thing too is that I want to see you engaging with the law. So, for example, I don't want to see a case just tacked on the end or a provision tacked on the end, but work with it. Draw out a key aspect. And many of you did that. It was really, I was very encouraged about that. But then I had some members of the group, for example, in reference to, say, a provision or whatever, they give me the entire section. I don't want to see the whole section. I don't need you to repeat the section. What I need is what you believe is the critical wording, critical feature with regard to judgment. You need to use that with care in terms of how you're using the judgment. But many of you have shown the capacity to see not just the what I would call the surface consideration, but sometimes the deeper ideas that are standing behind what's going on in the judgment or the decision, which is good and very encouraging. You might say, well, if that's so, Michael, how come there weren't more high distinctions in quiz 1? That might be a consequence of the fact that I'm fairly strict in my marking strategies. But look, just on the comment on the quiz in particular, quiz 1, I was really encouraged by the depth and the breadth of many of the answers that I was reading. I thought sometimes there could be a more systematic development of the logic of the answer. I think that certainly work can be done with some of the group in terms of being more precise and concise in ways of expressing. And this is a skill, this is an evolving skill. Every time that you write anything, you should seek to improve on what you wrote previously. Make it more concise, make it more to the point. Plain language is to be commended. I don't need your answers to be adorned with legalisms or legalese. I mean, obviously sometimes there are technical words. Melodialism, for one, for instance. Trying to get our tongue around that. But, I don't need those other things. You need to basically get to the nub of it. Because, particularly, for example, in the context of the quiz, you don't have a lot of space, and I know that there's been a few technical challenges there. I mean, I faced a few technical challenges, I have to say, in the grading of it. Not in actual reading your answers, that was some of those I found most enjoyable, but just in the actual grading. For example, I gave you the opportunity, and I actually just, as before we finish this evening, I'd be interested to hear any feedback on this. I gave people the opportunity to do multiple attempts at the quiz. Quiz questions, and I know there were a few issues there initially about, well, logistically, how do we do that to make sure our answers got saved and whatever. But at the end of the day, what Moodle actually does then, it actually saves every attempt. So in some cases, for some students, I had multiple attempts for different questions, and then I had to make sure I was looking at the final attempt, and the actual way that I go about it from my end, sometimes that's a little bit challenging. But did people find, for example, that opportunity to make multiple attempts, was that useful or not?
Michael, I certainly found it useful. That I could do something, put it up there, maybe go away for a while, come back, have a look, have another read of the text or whatever, and change some things around, have another go at it. So, yes, I did find that useful.
Yep. I was talking to IT today, and apparently there is a way that you can actually save an answer without submitting it, but then come back to it and add to it further, so that you're not actually, it doesn't get recorded as multiple attempts. But if you have, for example, an internet outage or something, then that can have an effect on that. So I was giving some contemplation to changing the nature of, just the technical nature of how the quiz 2 was conducted, but I think I've decided, for reasons of not confusing people any further, we'll stick to the same protocols, if you like, because now I've got a better handle on where there are multiple attempts to work out the final attempt and so on, as we did for quiz 1. But I've streamlined it a bit so that there are less questions. They're all of equal value. There will be a mixture of discussion or essay style and problem solving. It's been a bit of a learning experience, I think, from different perspectives, including for IT, by the way, because I don't think there's been a lot of other people that have tried to do a quiz quite the way that I've tried to do this quiz, or did the first quiz. But look, we had a few issues that I dealt with it progressively throughout, and everyone in the end seemed to, there was only a few people only like a couple that had real technical difficulties, but most people in the end seemed to work things out and work out how it worked. And we've had that experience for the first quiz, so the second one is at the end of the week. And look, the other thing I just want to ask about the timing, I've had a few people say there's some concerns about running it over the weekend. I'm aware that, people with family commitments and so forth, there are some issues there, but that was one of the reasons that I basically put it, part over the weekend, part over a weekday. Has anyone got any comment on the timing of the second quiz? So I'm running it from 4 p.m. on the Saturday after Anzac Day, the 26th, through until 9 p.m. on Monday, the 28th. Okay.
Yeah. Weekends definitely suit me. I work full time, so it's a bit difficult to even coming into the tutes to make it. So exams and online quizzes over weekends are great.
Thanks for that, Nick. I appreciate that. I know that the cohort of students come from a whole range of backgrounds, and I know that my students are, and in the program generally, of course, not just in my course. You're not the typical, young undergraduates coming just in from high school. I know that. All of us in the program know that. And we also know that you are doing this program because one of the reasons is because of the flexibility that the online law degree offers, that you wouldn't be possible if you were in a more conventional environment. You had to physically attend classes normally during daylight hours. Certainly wouldn't be attending a class, at a sandstone at 8 o'clock at night in a law school. You could be in the library until midnight or beyond, that's true, but not in a classroom, or certainly not with a professor. So I know that, and look, I want to say that I think that the flexibility, what I actually call, what I'm using a phrase, practical flexibility, it's not unbounded flexibility, but practical flexibility, practicable flexibility is very important. And I'm really have tried in everything that I've done in the course up until now to engage with that. And so again, the reason for the delay of the second quiz was because of the public holidays interceding, because of the rescheduling of tutes, and also wanting to get the tute on with regard to the topic 6 before you do it as well. And then thinking about issues of commitments, that's the reason I straddled it in the end across the weekend, but into a weekday as well, to accommodate, students that prefer doing things in the weekday. Students have preferences for weekends and so forth. So I hope I've got a mix right there. One other thing, can I just ask, and this will influence me to some extent going forward into term 2 for land law and conveyancing, both courses which I'll be running in term 2, by the way. Timing of tutorials. Now, this term I've put the tutorials during the daylight hours. Is there a good slot? Is there a good day of the week for people? I I obviously got my own concerns and how I decide to do that, but I'm interested to know if there's any comments you'd like to make about that. I can take those on board and think about those going forward into term 2.
Michael, along the lines of what Nick had to say as well, work full-time, odd hours at some stages, so 7 to 8 o'clock is another Zoom session I do have. It fits in quite well, bearing in mind I know other students do more than 1 or 2 subjects, so it might conflict there, but 6 to 7, 7 to 8 is always pretty good for me.
Thanks for that, Luke.
Oh, there we go. I generally find that I'm pretty flexible, but anything around that 5:30 to 6:30 can get a bit tricky for me with getting dinner on the table for kids. That's the only thing, and it can also get it's workable, but it can get a bit tricky when you're juggling another 2 or 3 Zoom sessions during the week as well. But apart from that, no, it's not too bad.
I've got a 16-year-old who's currently saying, "Where's dinner, Dad?" So luckily my 14-year-old and my 12-year-old are not with me at the moment. But that's been fun and games. As I sent an email to one student today that because I'm in New South Wales and my kids have been on school holidays now for over a week and a half. And with the commitments and the demands of the course, basically no time to do anything with them. Anyway, that's just but yeah, I appreciate that. Thanks for that, Lisa. So can I just get maybe a show of hands or whatever, daytime or evening, any preference?
Oh, look, daytime would probably be my preference, but I'd be happy to go with the majority.
Nighttime, definitely for me.
Yeah.
And like someone else said, the 5:30 slot's a bit difficult. Maybe a little bit later, maybe starting it at 6:37,
Okay.
just so we've got time to get other things sorted after work.
Yeah. Okay, that's good. Thanks for that. Margaret, did you want?
Yeah. I can work in with the others. I don't have any kids, so whether it's during the day or at night, but the only issue for me is how it corresponds with, because I'm doing a full-time load, so there may well be other sessions on, but I'll juggle that around this semester anyway of 1 week on with 1 week off. So I'll sort of go with the majority.
Yeah, okay.
Michael, just in relation to the Zoom session Thursday, what time is that, do you know, at this stage?
I was thinking, of course, that's the Thursday before Anzac Day.
Yeah.
I was thinking, is anyone doing Principles of Commercial Law with Chris Walshaw? No, okay. I'm sharing a Zoom license with him, that's all. I've got a feeling he has classes on Thursday, but I'll have to just check that. From what I'm hearing is probably a bit later than 5:30 would probably be the preference. I'm certainly thinking of doing it later in the day, not like 11 o'clock. It's not doing commercial law, okay. So I'm sorry, Luke, I need to be more specific in my response. I haven't set a time at the moment, but subject to the licence not being used by my colleague, I'm thinking in the evening, and probably I'll make it a bit later then to try and work around people a bit more, because it seems clear that 5:30 is a bit early. Yeah.
The reason I asked, I suppose, is I know myself and Margaret might attend as well. There's a Stephen Colburn. He's got legal professional conduct one, 7 to 8 on Thursday. I don't really mind if I don't attend this one in preference of the other one. If it was beneficial to go up online prior to the quiz opening, so we could have a look at it then, that would be also something to consider.
Well, that's right. Of course, we record. I am recording. I know. Sorry, the last one, not today, but the previous tute, there was a technical issue that recording didn't happen. But I've recorded all of this session, all of it, getting up to nearly 2.5 hours of it today. I will make every endeavour to get it posted, loaded up just as soon as I can. Last time I remember I had huge difficulty because of the size of the file. But Stephen did indicate to me that the best time to attempt the upload is in the wee hours of the morning. So I'll set the alarm at some hour. I do often get up very early, but I'll endeavour to get that up there before the quiz opens on the Saturday. Stephen's got his class, you said, from 7 to 8. Yeah, well, look, I think it's, maybe I can run it from 6 until 8, and then those that are going to Stephen's class will have the benefit of the first hour. And if there's anything further after that, then those that are still with us can continue. So in that way, Luke and others who are doing Stephen's course, you will have the benefit of some of the face-to-face time, and I certainly appreciate you making the effort, and I think that's good and valuable. But you'll also have the benefit of the recording, making sure if all goes according to plan, and I'm able to get it up there before the quiz opens on Saturday. So maybe that's the best arrangement if I make it from 6 until 8 p.m. I didn't do that last week, basically because it was the Thursday before Easter, and I was conscious that people might have had obligations and commitments in a range of ways pre-Easter, but I don't imagine that's quite the same for Anzac Day. I suppose with the exception of those that are rising for the dawn service. But in any event, you'll get at least a couple of hours sleep between the end of my tutorial and the dawn service. Any other things that you want to talk about generally with regard to the course?
I just had one question about the online quiz 1. On the grades view, it's showing that the range is out of 100.
No, that's not correct. It's out of 15. Yep. So the marks.
Yeah. Okay.
Don't worry about that out of 100. The mark is a mark out of 15. Okay, so it's not 11 out of 100, for example. In fact, if it's 11, it's a very good mark, by the way. I don't know what your mark is. But, just.
I figured that was the case, but it had me a little bit worried.
No, please don't worry about it. And look, the other thing is that, I had at least one student say to me, "Oh, Michael, I'm not sure, did you mark my latest attempt or whatever?" And I looked at that and re-examined that, and I sorted that out. And there was only a couple of students in that situation. Most of it, I was very vigilant as to marking the last attempt. And I've got a better handle on the process now this time too, So, but look, the results on the quiz, there were a couple of really excellent responses. I think the highest mark was over 14, which was really, I was surprised at that. I don't normally give such a high mark. But I was marking, the nature of this quiz was that I had to mark by question. And, you know, even though I knew, like, the student's name was there, but it wasn't really any consequence really to me. But I was marking by question, so I didn't really know what the total was going to be until I saw the totals in the end. And I'm always pleasantly surprised in my marking, in the sense that the distribution of results after, you know, having done this sort of thing for many years, always comes out to be pretty respectable in the end, in the sense that we get a good distribution of, as we would normally expect from a cohort. But, 14 up, that was a pretty stellar performance. But, there were some very nice answers, really, and I was actually quite impressed by the amount of work that some students had put in. And some people had some fun and games with references and footnoting and trying to work that out in Moodle. Please just let me say on that point, I'm not at all concerned in the quiz that you necessarily need to adopt footnote referencing, but you do need to show me the law that supports your answers. I need to see the cases. I need to see the provisions of the legislation. I need to see the reference to the academic commentary. And if that's what I ask for, and I specifically ask for case law and academic commentary, that's what I expect. I expect reference back to what, the materials that I'm asking you to work with, not other books that may have been prescribed in previous years, for example, even though there's an overlap of material, but, that's important. So I think the average, the average mark, I looked at it this afternoon, across all the results for quiz 1, I think was about 61%. So that's a pass, very solid pass as the average. And hey, look, if you've scored a credit or better on this quiz, you're doing well. And if you pass the quiz, you've got a solid number to go forward on, which is important. And it's a building process, it's a building process, so that you've been through the first quiz. And this is part of the developing an assessment strategy like this. And I remember many months ago talking with Stephen about, on the one hand, from his role as head of program, saying, oh, we've got to do this, we've got to get this, and I was saying, fine. But these are what I want to achieve as the person in charge of the course. And one of the things that I want to do is I firstly want to have a variety of assessment mechanisms, which is evident from what I've settled on at the end of the day. I want to have mechanisms that facilitate more student interactivity and engagement. I want to have assessment mechanisms that give student feedback progressively throughout the course so that they've got an idea of how they're going. I don't want an assessment regime that leaves everything till the end. I think, in particular, in a course like this and in a program like this, I think that's important. So, you've all got that, but I know that most of you, if not necessarily all of you, but almost all of you can certainly build on your result from quiz 1. You've also got, from the classes, from the tutes, from the way you see my course evolving, the way you see my strategies, you're getting a sense of what concerns me in property law and what I'm trying to get you concerned about. So, that will hold you in good stead as well. My 16-year-old is not the only one getting hungry. I have to say. I'm hoping that this sort of open session is beneficial, because I think I'll plan to run a couple more like this before the course finishes. I'll certainly run a session pre the final take-home exam in regard to that.
Can I just ask, what week of the course do those take-home exams come out?
Yeah. Did you? did you send me that email, Lisa? I think someone, yeah, anyway, that's fine. I've, at this stage, tentatively scheduled mine for the review week, at the end of the review week. Okay, that is for when you get the questions. Okay, and I will, I think, use the same process that I've used for the quizzes. This is not going to be through Moodle, but in the sense of the time frame of about 48 hours. Again, there's been discussion with my colleagues about time frames, and I know that some of my colleagues are, how do I put it, they sort of take a more stringent view about this, saying it, must be this, whatever. My view is that certainly we need to have a clear parameters, but I think that a little bit more time rather than a little bit less time, I think, is appropriate, all things considered. So, I'm really thinking about 48 hours for people, and I take on board the comments about weekends and these sorts of things. I think, proposing to release it toward the end of the review week, because basically I wanted to give you a week to get your, to go back through and prepare yourself for the final. I don't think it's fair to impose that upon you as soon as classes are suspended. That's a bit silly or ridiculous in my view. But that was my thinking. But I'm happy to again have views put to me on this. It's not been completely finalised, and the fact that it's been, it is in this way, again, this is indicative of the practicable flexibility that we're applying in the program. See, if we had invigilated exams, everything would be locked down, done and dusted, 5 years ago, almost, in terms of when it was to happen, how it was to happen, and so on and so forth. But when we do it like this, and you'll notice, of course, that it's not called an exam, and it can't be technically called that, otherwise it gets caught up in the invigilated exam process. But it literally is a take-home exam. But the truth is that we have a lot more flexibility, because we are actually the person in charge of the course then just has responsibility for doing the whole thing and managing the whole thing themselves. We don't go through exams. It doesn't get through the central administration. There's none of all. So this issue about how long, precisely when, we can be more responsive to our cohort of students and do it in a way that tries as best as possible and practicable to work with the different circumstances of people and what works best and so on and so forth. But that's the general thinking at this stage, Lisa. Yeah.
Okay, thanks, Michael. Well, I don't have any more questions, so I might say goodnight and have a nice dinner.
Okay, thank you. Thanks for that. Thanks for joining.
Thank you.
Okay, good night all.
Margaret, adieu.
Yeah.
No allodialism, please. Okay, all right. I might call it. Anyone else got any questions before we close off, or no? Okay. All right. Thanks for that, people. And is that Luke?
Yeah, thanks, Mark. Yeah, no dramas. Just saying good night.
Okay. Good night, and
Thank you.
arrivederci. I'll turn off the recording now, and I'll post this up just as soon as I can. Okay. Bye for now.
All right. Thank you. Bye.